Well, I guess we can get started. Our last panel of the day is on ethical and professional standards for lawyers and engineering experts in water court litigation and dispute resolution. I'm Steve Lenhart. I'm a partner with Burns, Figa & Will in the Denver Tech Center, and I've been practicing water law for 30 years, more or less. We've got still have some ground to cover, and I know that the program as a whole has been running a little late. We're sensitive of the time, and we are reserving time at the end of the panel for question and answer, but also try to get everybody promptly off to the reception at the end of the day. So we're going to talk right now about ethical standards for both lawyers and engineering experts. We have two of each on the panel, and the roles that we both play and how those roles and rules have changed in the past 10 years. Justice Hobbs has talked about Colorado's water adjudication system. We had a morning panel that talked about the battle of the experts and how that plays out in various court proceedings. Battle of the experts, of course, is front and center in a lot of water litigation, and particularly the engineering experts, often armed with computer models, will work with lawyers and clients in both litigation and resolution of disputes. So there are ethical rules and ethical roles for both lawyers and experts. We each have distinct roles that we play, and there are some cultural differences, as one of the speakers this morning referred to, but we do need to collaborate, and how do we best do that in a way that's helpful to the court when we're in front of the court, and in a way that's helpful to resolving disputes for our clients. So let me briefly introduce the panel. Everybody's biography is in the booklet. Janet Williams will be speaking next. She's the chairperson of Leonard Rice Engineers, a longtime top water engineering firm in Denver. She is an experienced and thoughtful expert witness and problem solver. Emma Schultz will speak next. Emma is an assistant attorney general for water with the Colorado Attorney General's office. Her clients include the state and division engineers and Colorado Water Conservation Board as state agencies, and she can talk more about who her real client is when she talks in a few minutes. She's also been in private practice prior to working with the AG's office. Kevin Ryan is the deputy state engineer, works very closely with Dick Wolf, who spoke this morning, and he's a leader in the state engineer's office on several issues, including water court litigation and legislation and policy issues. So first, just to summarize the variety of different rules that I will be talking about today. For lawyers, rules tend to multiply, and that's certainly been the case over the last 10 years. Particularly, we will be talking about the water court rules and some important ways in which those have changed. But we can't just look at the water court rules in a vacuum, and particularly when we're talking about ethics for attorneys, we've also got the Colorado Rules of Professional Conduct, or CRPC. In court proceedings, we also have Colorado Rules of Civil Procedure, or CRCP, and those closely follow the federal rules of civil procedure. Of course, the water court rules are central to the presentation, and the federal rules and Colorado Rules of Evidence are also important in defining the roles of expert witnesses. Lawyers play different roles that are recognized in the Rules of Professional Conduct. Now, the preamble of the rules talks about lawyers' roles as advisor to our clients, providing the client with an informed understanding of their legal rights and obligations. The lawyers' roles as a negotiator, which is important for dispute resolution, seeking a result advantageous to the client through negotiating a transaction or a settlement with other parties. And last but not least, the lawyer's role as an advocate in the adversary system, and often referred to as the role of a zealous advocate. Back when I started practicing law, there was actually a canon of professional responsibility about the lawyer as zealous advocate. The current rules, however, make it clear that being a zealous advocate is a role that lawyers play, but it does not under any circumstances justify conduct that is unprofessional, discourteous, or uncivil. Now, some of the key obligations under the Rules of Professional Conduct are obligations of candor and confidentiality and disclosure. Confidentiality can sometimes be in tension with the other two, but particularly in court proceedings, first and foremost is the obligation of candor, to be truthful in your statements to the court, your statements to other parties, and in the evidence that you present. There's a Rule 3.4b that prohibits a lawyer from counseling or assisting a witness, including an expert witness, to testify falsely. So truthfulness in evidence is crucial in candor with the court. A lawyer has a duty to refuse to offer evidence that the lawyer knows to be false, and if the lawyer has offered some evidence and then learns later that it was false or incorrect, then the lawyer has a duty to take reasonable remedial measures after the fact until the conclusion of the proceeding. And there's a, in tension with the candor rule, and particularly there's a provision that says when you have a disclosure obligation under this rule, it applies even if information would otherwise be protected by the confidentiality rule. That's a pretty rare statement under the rules of professional conduct because one of the lawyer's strongest obligations is confidentiality of all information relating to representation of a client, whatever the source, under Rule 1.6. This obligation covers all matters related to representing a client, subject to some limited exceptions that permit disclosure, do not require disclosure under Rule 1.6. The most important is probably the most common sense, that where you have a client's informed consent to disclose something, or a client's implied authorization, and we'll talk about that a little later in the context of dispute resolution. The confidentiality obligations that a lawyer has under Rule 1.6 extend not only to the lawyer's employees, but also to consultants that the lawyer retains. This comes into play with what we call a consulting expert witness, which is different than a testifying expert witness. So for a consulting expert who's not designated to testify in court, then confidentiality is the rule, and it's important for the lawyer to make clear that confidentiality expectation in retaining the expert. However, when an expert is designated to testify, then even otherwise confidential information becomes subject to disclosure and discovery. So what are a lawyer's disclosure obligations regarding experts? A lot of that's laid out in the rules of civil procedure, and the water court rules have expanded on that somewhat. Talking about experts under both the civil rules and the water rules, you really need to give credit to an organization right next door here, the Becky Love Corliss's Institute for the Advancement of the American Legal System has been instrumental in proposing several reforms. They were involved in the early days of the Institute, in the early days of the consideration of the amended water court rules, and also have been involved in some major proposals for reform that have been considered in recent years in both the Colorado and the federal rules of civil procedure. So one of the important ways in which the rules have changed pertains to disclosure of confidential information that an expert has. And under both the federal rules and the Colorado rules, there was an old notion that basically kept expanding the ability to discover virtually anything in an expert's file, including any draft reports that the expert happened to retain and any communications between the expert and the attorney. And finally, the Federal Rules Committee said about 7 years ago, no, we're not going to keep expanding these collateral games, we're going to turn it the other direction. And the federal rules have been, were amended in 2010 to basically provide for disclosure of the expert's opinions along with the facts or data considered by the expert, but not the other information that may be there as well. So the factual information that the expert actually considers is what's discoverable, but the federal rules have said we're not going to get into these collateral battles over draft reports and over communications between the expert and the attorney unless it actually consists of facts or assumptions that the expert considered and relied on in forming their opinion. So the Colorado Rules of Civil Procedure went through a similar change about 5 years later, and the Colorado rules, of course, for the most part apply in water court, including this amendment, and the 2015 amendments are only applicable to cases filed on and after July 2015 absent consent of the parties, but much like the amended federal rules, discovery of expert drafts is now generally prohibited, and discovery of expert communications with the attorneys is now generally prohibited and outside both disclosure and discovery, subject to similar exceptions that assure that anything that's actually material that the expert considered in forming their opinion still is subject to disclosure. The other key Colorado civil rules disclosure reform is that the civil rules kind of caught up with the water court rules a few years ago and now require experts to provide all of their opinions in a report, all of the basis for their opinions in the report as well, and that the expert's direct testimony under the civil rules is now limited to matters that were actually disclosed in detail in that report. The Colorado Water Court rules, Justice Hobbs talked a little about the Water Court Committee formed by Chief Justice Malarkey in 2007 that considered how should the water court rules be amended to make the water court practice more efficient, hopefully to cut down some of those transaction costs that some people have raised as a concern. And one of the key considerations right alongside that is what is the proper role of an expert witness in a water court? The Water Court Committee had a subcommittee on expert witnesses that looked at the importance of the accuracy and credibility of scientific evidence that's presented to the water court, and how this battle of the experts relies so heavily on what are the experts' opinions. Are those opinions pure advocacy favoring one client or the other, or are those opinions actually trying to reach the truth and trying to be helpful to the court? And the subcommittee also looked at a survey that had just been conducted of water judges in Colorado and their counterparts in other western states. And a strong majority of those judges believed that there was a real problem with advocacy science in the presentations in water court and similar courts, and how do we change that? How do we turn that around? The committee decided that the solution was to make the role of the expert in water court proceedings more clear, and to require additional information and disclosures, as well as in meetings of the experts, which we'll talk about in a few minutes under dispute resolution, in order to limit the advocacy nature of the expert's role in water court proceedings. So the committee decided expert opinions under the federal rules of evidence, first, and the federal rules and Colorado rules of evidence that follow them. The main role of an expert is to provide specialized knowledge that will assist the trier of fact to understand the evidence or to determine a fact at issue. And in order to do that, the Water Court Rules amendments emphasize that the expert's primary responsibility isn't necessarily to the client who's retaining them to provide opinions, but is to the court to help the court sort out the facts and make the right decision based on the scientific facts and evidence. So the Water Court Rules implemented this, first of all, through some disclosure requirements. People talked about transparency with regard to computer models this morning, and that has been a problem in water proceedings and frankly in all kinds of proceedings where scientific evidence is at issue. So the disclosure requirements in Colorado now include disclosing an executable electronic version of any computational model that the expert relies on, so that the computer models that are used are to be transparent and not just a black box. The experts for the applicant are the first ones to provide disclosures. They are to be accompanied by the applicant's proposed decree, so the findings in the decree and the findings in the expert report tend to line up with each other. And then the opposer's expert reports provides reports a few months later, and then in the midst of this process is the expert meeting, which is the key to the expert's role in dispute resolution under the current rules. But the one other thing that the expert needs to provide under the Water Court Rules in Colorado is a declaration signed by the expert with every report, every disclosure that's issued naming that expert as an expert witness in the case. Verifying that the expert's responsibility is to the court, that the attorney has not suggested any material for the report without the expert forming their own independent conclusion on the matter, and that the expert has not withheld any significant matters from the report regarding their opinions. Let me talk about dispute resolution for a minute, since we're getting toward the end of my time. Dispute resolution in water court is getting increasing attention, I think, because most contested water court cases should settle, and most do settle, but often that happens within the last week or two before trial, which has real effects on the court system and on the cost to the parties. So how do we resolve disputes as lawyers and experts in water court proceedings? First of all, the attorney has some duties under the Colorado Rules of Professional Conduct to defer to the client's ultimate authority on whether to settle a matter. That's part of the client's overriding role in dictating the objectives of the lawyer's representation, and also to communicate promptly with the client any settlement offers or similar information that requires the client's consideration. Lawyers also have a duty to make reasonable efforts to expedite litigation. I think this includes reasonable efforts to expedite the dispute resolution process. The lawyer is also bound by confidentiality, but the comment to the confidentiality rule recognizes that this implied authorization for lawyers to make disclosures can include disclosures made to facilitate the client's objectives in settlement negotiations. The dispute resolution follows basically the two components of the water court process. Most water court cases first go before the water referee. We're fortunate to have a few present and former water referees in the room today, and value their role in this proceeding. The referee, first of all, has a statutory role to investigate each application that's filed, but under the 2008 amendments to the water court rules, the referee also has a much more defined role in facilitating resolution of contested applications within a specified time frame. It used to be that cases would languish on the referee's docket for several years, and that's no longer allowed. There's a presumptive one-year time frame that can be extended up to 6 months. But the referee convenes the parties to prepare a case management plan in an initial status conference, and that plan then sets forth how and exactly when are the parties going to exchange information that's needed to resolve the dispute, what information is going to be needed, and then what is the time frame for trying to resolve all these objections. Now there are some cases where the parties or the referee will recognize up front, or sometimes maybe the judge will recognize up front that this isn't an appropriate case to go through the process on the referee's docket, because the only way it's going to be resolved is to go through this more formal process in water court. But the key dispute resolution process when a case is before the water judge is through the meetings of experts. And that was the other component of the water court committee's expert subcommittee, is that it's helpful for the experts to meet without the attorneys. That was really revolutionary. Without the attorneys in the room, and see what progress they can make in resolving the disputed issues of fact for expert testimony. They don't have authority to settle the case, obviously, without the client's input and the attorney's review, but they do have the authority to talk about what are the real issues for the battle of the experts, what can we agree on, and what are the legitimate disputes that need to be taken before the court. And of course, as an attorney, I've never been in one of these expert meetings, so I expect we'll hear a little more on that subject from Janet and from Kevin. Last but not least, we now have, as was mentioned earlier today, we now have a growing role for mediation in water court proceedings, thanks in part to the availability of Senior Judge Hobbs to serve as a mediator over the last year or so. And the attorney's duties in mediation process are, number one, advising the client before and during mediation. Is mediation a good idea? evaluating the other party's position on both the legal merit as well as the factual accuracy of those positions. And does the other side actually have some positions that are consistent with the client's objectives? Then the lawyer represents the client as an advocate and a negotiator in the mediation, which is really a different form of advocacy than we see in litigation, because it's aimed at building consensus on solutions that will work for all the parties, and negotiating decree terms with input from the mediator, and obviously with input from the experts during the mediation process. It's very important for the lawyer through this process to identify the client's interests and to facilitate achieving those interests. Weighing what are the client's primary objectives, how interested is the client really in resolving this dispute versus continuing the litigation. What are the financial interests, including the litigation costs? What is the interest in ongoing relationships with other parties? For example, relationships among water users on a stream system or in another shared resource, such as perhaps a ditch company. And to realistically evaluate what are the potential litigation outcomes, what are the risks, what are the trade-offs. An early mentor of mine had a saying that a bad settlement beats a good lawsuit. And that lawyer had a good lawsuit many, many years ago called the Hinderleiter case, and we've just heard how that one turned out. So that's why a bad settlement can be better, and I think a good example of that too is Ken Salazar's talk today about the Colorado River system and how collaboration wound up working a lot better than the parties asserting what might seem to be good legal positions. Attorneys can also serve as mediators, which is another set of rules. Attorneys in mediation have ethical obligations for, first of all, in Colorado, advising their client on what forms of alternative dispute resolution may be appropriate. Sometimes it's the attorney's duty under the rules to raise that issue. And to negotiate with truthfulness, especially in any statements of fact. It's important to be candid with the mediator as well. It helps the mediator to help your client. And finally, there's a duty of confidentiality for attorneys and all other parties in mediation, because it's not only under the attorney ethical rules, but there's also a mediation confidentiality statute in Colorado. And Justice Hobbs, I think, has reflected that well in his standard mediation agreements. So parties are bound by contract, by statute. Attorneys are also bound by the rules of professional conduct to observe confidentiality in anything that happens in mediation. So in conclusion, we have not just more rules, but also more tools that we can use in resolving disputes. And as lawyers, I think we can work better with our experts, with water referees, with mediators to problem solve and resolve disputes before it gets too late in the game. I'll turn it over to Janet, and hopefully she'll help tell us what lawyers can learn from engineers about working together to solve problems. Thank you.
I'll bother you with one quick question.
At the end of the panel.
Expert rules. Do I have to disclose what I
questions at the end of the panel. Thank you.
Okay. It's procedural.
Good afternoon. Thanks for having us here, and thank you, Steve. So I'm Janet Williams, and I will talk about the ethical obligations and principles for engineers serving as experts, and I'm here to provide the private consultant's perspective. I'd like to talk about our duty, to whom do we have a duty under our code of ethics, objectivity, how we try to maintain that, and talk about bias and being objective, the expert meetings and how that fits into the mix, collaborating with attorneys in writing our expert reports and some of the ethical questions that come up about that, and then our role in mediation. So who do we owe a duty as an engineer? ASCE, the American Society of Civil Engineers, publishes a code of ethics, and what it states is that engineers shall hold paramount the safety, health, and welfare of the public. It also states that when we practice, we need to do it with honesty, impartiality, and serve with fidelity the public, our employers, and our clients. And then the next one is I quoted from Steve's presentation. Our duty as an expert witness is a duty to the judge, as he's already stated. Our role as an expert witness is to provide technically accurate information and to provide unbiased and objective judgment and information to be a resource to the judge so that it can assist him or her in understanding and evaluating the facts of the case. So according to these codes and rules, we certainly have a duty to represent our client as well as we can, and we also have to honor the interests of the public and represent our firm and our profession with integrity, and to serve as an objective resource to the judge. Sometimes these interests seem to be competing, and so we have to consider the different perspectives and balance all those different competing interests. And I feel that having to balance those different interests, it actually helps us with the objectivity piece. So I'd like to talk a little bit about how do we maintain objectivity and how do we remain unbiased, because that's, I believe, one of the big ethical, major ethical considerations that we really consider as engineers and as expert witness on a continual basis in our practice. Especially in water, we often serve the same client for decades. We have long-range projects. There's clients with very complicated systems and complex, intricate decrees with a lot of nuances. And over the years, we build up an expertise in their particular system, and we build a relationship with them. We like them. We want to help them. And then also, as you've heard in some of the other presentations, water rights is not a field with a lot of black and white. There's a lot of gray area. And so most of what we do is not just a right or wrong, what's the right answer. It's a lot of judgment and assumptions and estimates. So there's a range of how we can decide to proceed with our analysis. And so when you put these together, our duty to our client and our relationship with our client and the fact that there's a lot of gray area, I think that it's easy to see how we could be biased and we could operate making judgments that tend to lean in our client's favor. So how do we maintain objectivity and how do we not get too biased in our practice? I think there's a few factors that help us maintain that objectivity. And I think one of those is that we tend to have multiple clients. Typically, we have multiple clients at the same time. We have a number of clients over the course of time. And these clients all come from a variety of perspectives and situations. And it's a pretty good bet that if I'm on one side of a contentious issue today for one client, then tomorrow or next week or next year, I'm going to find myself on the other side of that issue for another client. And the last thing I want to do is show up and look a judge in the eye in two different court cases, in two different trials, and provide two different opposing opinions on the same issue just because I was being loyal to a different client. If I do that, my credibility goes out the window, and as an expert, that's my main asset, is my credibility. So there's a lot of incentive there to be really careful, to be consistent in our opinions, and to consider both sides of an issue. And so what I learned as a young engineer, and what we try to consider as we work through a project, is when we start an analysis or a piece of analysis, we look at what are the best practices, what are the issues, and how is the best way to go about this, and try to look at it objectively. And then we have to step back and say, okay, here's how we propose to do this. But what if I were on the other side of this? What if I'm representing another client who would be injured by this? What if I'm representing an objector in this particular case instead of the applicant? Then what would my opinion be? How would I look at it, and how might I do it differently? And when you look at it that way, is the answer the same or is it different? If it's different, is there a justifiable reason for that? Or is that something that I need to reconcile? because that situation is going to come up. So I think that little exercise of backing off and looking at the other situations sort of helps to maintain that objectivity. So I believe that having a variety of clients and looking at different perspectives helps us to maintain that balance and maintain a perspective on those issues. Because ultimately, even if the choice we make is maybe not the most favorable analysis for our client, it's ultimately more favorable for our client if we are a credible witness and if we try to do it right. Another factor that I think helps is the objection process. When we put out an expert report in a case, everybody that is objecting to the case can hire a lawyer and hire an engineer who will review our report, and they will provide responses in their reports, and it sort of becomes kind of like a peer review process. And I'd say our colleagues are pretty good at pointing out to us when we are biased or when we do something that they don't feel is appropriate. And so there's some give and take and some feedback there. And that leads me into the expert meetings, because that's where a lot of that feedback and that peer review type of process takes place. I have found that for the most part the expert meetings have been quite beneficial. Of course, it depends on the attitudes of the parties involved. Just like anything else, things tend to work well if people come who are engaged and open to discussion, which I've found that most of the time that's the case. And typically what happens in the expert meetings is at the very least there's a benefit to getting everybody in the room and just going through the issues and just explaining and clarifying. There's usually at least something or a few issues where maybe there was something put into a report that you didn't understand or you thought was going to be a big deal and a difficult issue to solve, and you explain it and somebody responds with, "Oh, is that all you wanted? Okay, no big deal." So just the communication is always a helpful thing. It also provides the opportunity for when sometimes there are a number of different approaches you could take to doing an analysis or solving a problem. And a difficulty that we sometimes have as an applicant is that we have multiple objectors who all want us to do it differently. And maybe it's an issue of any one of them could be considered reasonable, and maybe our client doesn't even care. It doesn't really matter. We just need to come up with an answer. But without this process, we may be settling with one objector, and then that causes the settlement with another objector to fall apart because they want different things. So if we get everybody in one room and can deal with that with everybody together, then it's much easier to come up with a solution that works for everybody. Sometimes that will backfire. Sometimes there's kind of the pile-on effect, which is not very fun to have all your objectors all together, but that typically is going to happen eventually anyway. So generally it's a positive experience. Sometimes I've had the experience where we need to come up with a way to solve a problem, and it's when all the objectors get together and we just start brainstorming and throwing out ideas that we actually figure out something that everybody can live with. So I do think that the expert meetings is a beneficial process, and I think it's helpful. So there are issues and questions, ethical issues that have come up around putting together and preparing our expert reports in collaboration with attorneys, which is what prompted the declaration that Steve talked about. I have colleagues in different engineering professions, such as geotechnicals or structural engineers, where they have told me that when they're preparing an expert report in preparation for litigation, it's considered highly unethical to collaborate with attorneys in that process. And the implication is that the attorneys are just telling you what to say and that the opinion isn't really your own. And I understand that, and I think that makes sense in their context. Water rights is a different animal, though. We cannot adequately address the technical issues in a water rights case without fully understanding the legal issues. The legal and technical issues are just too closely intertwined that you can't separate them out. And I think as a sort of simplistic example of that, every time I've been asked to serve as an expert witness or written an expert report, I am asked to express an opinion as to injury. And injury is not just a technical question, it's got a technical and a legal aspect to it. Without the legal part, I can't say if it's injury or not. I can say if a certain operation might short somebody some water, but if that water is not water that they were legally entitled to anyway, then maybe it's not injury. So we have to collaborate with each other. We have to share the information. The attorneys also need the technical information to adequately address the illegal issues. So there has to be that collaboration. But with that said, we have the duty to be careful that we take the input on the legal issues, but then we do our analysis based on our own judgment, and we have to make sure that our opinions are actually our own opinions and not just the suggestion of the attorney. So we have a line to walk there, and it's important to understand that and be conscious of that and honor that. And that's what the declaration that Steve mentioned is stating, that it's acknowledging that we do work together with attorneys on preparing our reports, and that's okay. And we understand that ultimately what we say is our judgment and our own opinions. So the mediation process, our role in that, as I've experienced so far in going through that process, is I guess kind of the culmination of all these other steps. And when we are in a mediation procedure, one of our roles is to explain the technical issues to the other parties in the case and to the mediator. The mediator typically has not been living and breathing this case like the rest of us have for months or years, and so we need to be able to help him or her clarify and understand the technical pieces of that. And then, as Steve was talking about, in the mediation process, there are potentially settlement offers that are discussed or offered or received, and we have to be present and available to evaluate those. There are some offers that it may not be immediately apparent to the client whether it even makes any difference or not. Sometimes if for example, an offer is, okay, we'll settle if you knock off X acre feet from your volume limits. Well, does that matter to them or not? Sometimes we have to actually put it into a model and model it to see if it matters or not. So we need to be available to address those questions so that we can advise the client as to, what do you think about this offer? What are the issues? What's the effect going to be to you? And then they can make an informed decision. So that's what I have. I will turn it over to Emma.
Well, my name is Emma Schultz, and as Steve mentioned, I'm an Assistant Attorney General with the Colorado Department of Law. I work in two units technically, and both are considered water rights units. I work in the Water Conservation Unit, which represents the Colorado Water Conservation Board, and I work in the Water Resources Unit, which represents the Division of Water Resources. I have to preface my comments by saying that my comments today are my own, my opinions, my thoughts, they're my own. They're not those of the Attorney General, and they're not those of my clients. And it's the way our life is in government sometimes. But I do want to talk about the duty of the Attorney General from my perspective and from my experience being an Assistant Attorney General. The Attorney General, as Secretary Salazar pointed out, is the chief legal representative of the state of Colorado. I believe Secretary Salazar said that he was the chief legal representative for the governor, but it's actually a little bit broader than that, being an Attorney General. The Attorney General is the exclusive legal representative for the state in all litigation with regards to matters of public interest. And that's a really big role, if you think about it. If there is something that affects the public interest of the state of Colorado, that's the Attorney General's job, and that's the Attorney General's role. So the Attorney General has some really big goals, which really include making sure that legal policy from out of the Attorney General's office is consistent and takes into account all of the interests of the state and its people. So the Attorney General considers larger interests than just agency interests, just division or department interests, or the governor's interests. The Attorney General considers the interests of the state and the citizens as a whole when determining the course of litigation. And with that duty, the Attorney General has some unique authority. There is, Steve mentioned the rules of professional conduct, which state that an attorney cannot settle a case without client authorization, but sometimes the Attorney General can. Attorneys can't initiate cases without client authorization, and the Attorney General can decide to prosecute an appeal of a decision that's adverse to the interests of the state without client authorization, without agency or department authorization or direction. That's part of this independent role that the Attorney General has. So this leads us to, as an Assistant Attorney General, what is my role? And as an Assistant Attorney General, the first thing I have to do is ask that quintessential law school ethics question, who is your client? And the answer for an Attorney General of any level is that the client is both the state as a whole, its people and the interests, the public interests of the state, and the individual agency or division or department of the state that you happen to be representing at that time. And these two interests, potentially, granted not very often, thankfully, but potentially these two interests, the interests of the two clients, might diverge. In practice, as an Assistant Attorney General, I work very, very closely with my clients. I confer with the state officers who are appointed and who work in these state agencies, and we collaborate on making decisions about litigation. I have certainly seen instances where the Attorney General's position is not one that's shared by all of the client agencies, but thankfully that has never been an experience I have had with my clients. So as an Assistant Attorney General, I have to keep a little bit of a different perspective, which I think is what we're talking about here, our different perspectives and our different roles. I have a little bit of a different perspective about what my role is in water court litigation. I'm an advocate for my clients. The rules of professional conduct and my licensing require that. I follow the rules of professional conduct and the rules of civil procedure, the water court rules. I'm the legal advisor to my client agencies. And I'm the coordinator for that process when we are involved in litigation. I do manage that. I keep track of everything and I take care of that and help my clients make decisions about what the best course of action is. And so with my clients are water administrators, or some of my clients are the water administrators. And as water administrators, my clients have a unique role. So I have a unique role and my clients have a unique role because my clients have statutory duties to the people of the state and to administer the waters of the state in accordance with the law. And in that unique role, my clients are actually my testifying witnesses. So my clients are my testifying expert witnesses, which puts us in a really unique position with these requirements that discussions about, or that the information an expert considers must be disclosed. And we work really hard to make sure that what we do in advocating for our clients and advising our clients takes into account this two roles that they have. clients as expert witnesses have a duty to the court and have disclosure obligations, but our clients are also entitled to legal advice and are entitled to have confidential conversations with their counsel. So one of the things that we try really hard to do is separate our communication when we're talking about legal advice and decisions about how to direct a case and what settlement positions we might take or what are the goals of the state as a whole. When we have conversations about what is best for the people of the state, what is best for my clients as administrators or as water right holders, those conversations we try to keep very separate from the conversations about their expert reports and their role as a testifying expert in cases. And one of the really unique things about having clients who are testifying experts is that my clients, unlike almost anybody else's, get to attend the expert meetings. I don't think it gives us any extra insight or anything, but my clients actually are authorized at an expert meeting to reach settlement if they can. And to make decisions that we will follow through the course of the case during that conversation, which I think really helps us drive towards settlement. And with this dual role, my role in water court dispute resolution almost takes a back seat sometimes because my clients are experts. My clients are water administrators, I'm not. My clients are all highly experienced. My clients got to go to the expert meetings and have coordinated on the modeling and those things. So in mediation or in water court dispute resolution, what I'm often doing is playing a role of being a creative problem solver. When personalities get in the way or when it's hard to see beyond the science for an engineer, which can happen sometimes, I can sit back and say, well, here's our broader perspective in looking at what our goals are for the state. And here's what you've told me your interests are in these other cases and in this other realm. And so we can come up with some creative solutions that address our concerns and also address our clients' concerns. And thankfully, I've had a lot of good luck with this in the role, in the times I have experienced formal mediation in particular in water court cases. Being able to maintain that broad perspective, but also take a back seat and let my clients decide, because they're the experts. So that's what I have, and I'll turn it over now to one of my clients.
Thank you, Emma. It's a little difficult coming at the end of such a prestigious list of people and speaking today, and hope to have something a little different to present to you and talk about, and I hope to be able to do that by talking about the role of the Division of Water Resources. It's a unique role in water court, as Emma just mentioned, and if we can talk about that role, and it's kind of refreshing for me to, having talked about that role before, but blend that in with a discussion of ethics, it's helpful then maybe to explore that in a different way. So I'm glad to have the opportunity to do that. So I will spend some time on the role of the Division of Water Resources in water court. It is unique, as we said, and it gives us some unique ethical considerations and professional conduct considerations. And we'll talk about the relevant ethical considerations that come into play then, and the potential for ethical conflict. And I say potential, but maybe not just potential, but perceived. I'll look at those two differently. And I'm going to do that in just a couple narrow cases today. And then how that plays into negotiation and mediation and and ultimately settlement of a case, since that is our objective in so many of these situations, and then where that process leaves the water court. What does the water court end up with out of our participation? I'll start then with the process and try to develop this role of the state and division engineers, the Division of Water Resources some more. Who is DWR? Why are we even considering this? Well, as Greg Hobbs said earlier, we are administrators. Since 1881, there was this role of state engineer administering water rights. We have that need then to look at any product of the water court, that decree, to ensure that we can use it to administer. It is administrable. Second, we have the role of, or we have that responsibility in compacts. We have a statutory responsibility to oversee these compacts and a unique role in water court to make sure that that decree that comes out does allow us to comply with our compacts as a state. And then third, we have this technical knowledge and we have knowledge on legal matters. How do we use that? Well, I believe we have this unique role, again, being called out in the statutes to consult with the court and to become a party. And that implies, as a state engineer, that we would use that technical knowledge and that knowledge on legal matters to participate in the court. Having said all that, we need to remind ourselves at the Division of Water Resources that we are not the decision maker in these processes. We are the decision maker when it comes to on-the-ground administration, but the water court in this case is the finder of fact, the adjudicator. I know I'm stating the obvious, but it's a good reminder for us that our role is to assist the court, much like Janet's role is to assist the court in getting to the right answer. We recognize that as our role as well. I just mentioned a couple terms: administrators, administration, and legal matters. And just to be clear, when I talk about administration, we're talking about that on-the-ground allocation of a scarce resource, and we do it in a very complicated system of water rights and water law and case law. And we do that basically with an imperfect or hard to understand infrastructure that's behind all that. So that's what I'm talking about with administration. And when I talk about legal standards, I'm talking about that statutory law, the case law, the rules and regulations that we need to adhere to, all of us. We need to look at the court to adhere to that in making that final decision. And that might include things like anti-speculation, duty of water, and questions of waste, diligence, abandonment, etc. So those are those not hard engineering but more legal matters that we still feel we have a role at some level, even if not the same as the technical role. With those the understanding of those terms, then we can look at our role as the Division of Water Resources and Water Court and break it down into those three areas that reflect what I just talked about: ensuring administrability in a case or in a final decree, oversight of the compacts and ensuring that we can comply with compacts, and again, as that technical consultant to the court and perhaps a consultant on legal matters, just to ensure that those legal standards are met, if nothing else, in the context of preventing injury, preventing expansion of use, coming back to those technical matters that we do deal with as engineers on a daily basis. There are three areas then that we interact with the court to carry out that role. First would be the monthly resume. We, as is our practice, we look at every case in that monthly resume because we have a second step that I'm going to mention now. We have that duty to consult with the court on a case. So that's why we need to look at every case in the resume, and then that consultation process. That's a second way we implement our role. And it's not just the consultation, but importantly, the reporting as part of that consultation process, because we need to ensure that we are being transparent and that process is, the outcome of that process is available to everyone. And then finally, the third one, participation as a party in the case. That would be the other way that we interact with the court. Each of those requires that technical understanding and technical experience and expertise that we have, but it includes, or it requires that knowledge of legal matters and legal standards, and it requires that we can bring those together in the right context with attention toward a decree that serves the water users well, allows that beneficial use of water without causing injury to other water users. That's how we need to bring that together. So it breaks down into administrability, compacts, and getting the case technically correct. All this goes toward then the court getting the right answer. That gets me into the question of ethical and professional standards and how those bring themselves into these roles and these tasks that I just talked about. So I'm going to narrow it down to just the two. Resume review, that's happening within our office. It's not true interaction with the court, but the two-way interaction does occur when we have the consultation and the reporting process first, and second, our participation as a party in the case. Let me focus on a few considerations as a backdrop as we do this. We have this special role with the court. The statute calls us out specifically to consult with the court. When we do that, we might be acting on incomplete information. Unfortunately, not every water court application is going to have all that information. So how do we treat that role when not all the information is in front of us? We need to consider, as Janet knows, that engineering, while it's not an exact science, not always, it is nonetheless objective. We believe that there are objective standards that we would work with when we're doing the engineering. And with all that, the engineer is going to use the best data available, the best methodology to arrive at the best answer, the objective answer. So let's go, I mentioned the two, consultation as one interaction with the court and being a party in the case. Potential conflicts in the consultation process, we need to ensure that we're treating the influence we have very respectfully and very fairly. We need to be objective in our consultation with the court. We need to be comprehensive. And we need to know that when that comes out, it's helpful to all parties. It's intended to be helpful to the court, but to be helpful to the court, it needs to be helpful to all the parties and very transparent. We need to pay attention to the fact that since not all the information is available, there's a little potential for us to wander off the path, maybe address issues that would not necessarily be present if we could see all the information. Or we may have there's a possibility that we would miss something because, again, the information is not there and we don't have an opportunity to comment on it in the consultation process. As a party to the case, ethical considerations. Do we pursue a principle or not? Especially as that principle might affect the amount of water involved. That amount of water could go one way or the other, depending on whether we pursue a principle. Do we pursue a legal standard or not? And do we consider to an extent what our role is with the court on legal standards instead of just technical issues? And finally, when it comes to mediation and negotiation, we need to consider the ethical implications of allowing an outcome that we don't regard as consistent with that actual true answer that we believe we came to in our expert opinion. I want to look at a couple relevant standards, the professional and ethical conduct and guidelines. Consulting engineers, and we would regard ourselves in the context of this discussion to have that apply to us, shall be objective and truthful in professional reports, statements, or testimony. They shall include all relevant and pertinent information in such reports, statements, or testimony. Very black and white. Another relevant standard comes from Rule 11E in the court rules. The expert shall not include anything in his or her expert report, disclosure, or opinion that has been suggested by any other person I think that's an interesting point. Including the attorney for the expert's client without forming his or her own independent judgment about the correctness, accuracy, and validity of the suggested matter. That's a second relevant standard for us to consider as we have this conversation. To reconcile all this then, as we proceed through this process, consider that the engineer's professional opinion, we're like consulting engineers. We're bound to be objective and truthful in all our professional reports, statement, and testimony. But we have to, and this is what I talked about reconciling, we realize that multiple parties are coming before the court, each with their maybe similar or not too similar version of what the right answer is. So we need to reconcile that. And that's where we get into negotiation and mediation and ultimately settling. That is about assisting the court in getting the answer as close to right as possible. And I would put quotation marks around right. We would think there's only one right answer, but what we're really trying to do is all of us help the court get as close to what is right as possible. And maybe instead of saying possible, I'll say as practical. Because anything is possible if you expend exorbitant amount of resources. But maybe we need to talk about practical and underline that word. That's what we're all trying to do. So the question then is, when we negotiate that outcome, if we've professed through our expert opinion our right answer, what happens when we're negotiating for something different than that? What would be a basis for negotiating on a hard number, on say a volumetric amount? Well, we might consider that the cost to pursue that right answer is disproportionate to the amount of water that's in play. That might be a reason to negotiate on a hard number. The facts, we may consider that the understanding of the facts is different. Janet mentioned the experts meetings. That's something that can come out of the expert meetings. We get a better understanding of the facts that we all have before us. Hopefully we all have the same facts, but we get a better understanding of the facts. We might give deference to previous cases, or by the same token, we might choose to not give deference to previous cases. As the state engineer's office and the division engineer, we may give deference to a previous opinion, or we may choose, or we may see that we shouldn't give deference to a previous position. We might give some deference to extraordinary circumstances. We might allow deference to the uncertainty that comes to the application of the law, the statutory law and case law, to certain situations. We like to think that the law is that clear guiding standard, but application to it always gets difficult. It means different things to different people. So that's on a hard number. The basis for pursuing an issue or not, we might, again, allow deference to the fact that there's uncertainty in the application of the law to certain situations. And we might, again, we're in this unique role, we might consider as the state and division engineers, we need to consider to what extent we should push a question or pursue legal standards in the settlement of a case. But the point, what I really wanted to bring together here is that through the negotiation, through mediation, and ultimately settlement, the ethical standards and professional conduct are intact, are protected. Because the engineer, that objective work, that stands, that's still there. As a matter of fact, it's maybe a baseline against which any negotiation, any sort of mediated settlement is measured. So we still have that baseline, and it gives us a guide as to what we're settling on. And then ultimately, as I mentioned before, the court is the adjudicator, and evaluating that outcome, whether it's right, is a subjective decision that the court ultimately makes. Thanks.
Well, I'm sure that there are plenty of opportunities for questions after those presentations, but we only have about 5 minutes before the reception begins. So with that in mind, any questions? Yes. Right.
This is probably directed more towards Mr. Ryan or Ms. Schultz, but Is the state and division engineer or the attorney general, when they represent the state or division engineer in an application in the water court, are either of those entities under an ethical obligation to fully inform the water court whether the state and division engineers have administered water rights consistent with the legal position that they may be arguing the water rights in that case should be administered to? In other words, what are the ethical obligations of your entities to fully inform the water court about your dual roles as an administrator of water rights and as to your legal or factual contentions in an individual case?
So the question is whether the state and division engineers have an ethical obligation to inform the court whether the position we're taking is consistent with our actions in administration. Is that?
I think, yeah, that's probably a better restatement.
Well, I hope I didn't take advantage of the microphone and state it so I could answer it better, but we would.
It's probably a better restatement.
We would hope that those are consistent. I think maybe that's what you're getting at. We would hope that our actions in the field and our representation of our position in the court are consistent, especially if we're talking about maybe similar structures or similar water rights. I'm trying to picture a situation, and Emma, I don't know if you're thinking about one where maybe that's not true, and we acknowledge that, and then I suppose if that were true, we would want to disclose that to the court. I don't know if you have a better understanding of that. That's a little bit of a nuance for me.
I think as part of the attorney's ethical duties for candor to the court, if we are fully aware that there is something completely contradictory happening, we probably do have a duty. I just don't know that I've encountered a situation where it's truly administration on the ground doesn't reflect our legal position in a case, in large part because a big part of the goal for the engineers in a case is to achieve the administrability on the ground.
If I can expand on that a little, the situation I've seen a few times over the years is where administration has recently changed in connection perhaps with the legal position of the case. And so applying that to disclosure of the past administrative practices up until the recent change. Do you have any more thoughts on that?
Thank you, Steve. And so that will happen. And maybe that's more, even a better statement of your question. Excuse me, past administration you may see has taken place one way, and then now that it's before the water court, you see something different. And I would say the explanation for that is that I think all of our understanding of what is happening out there evolves and refines itself through time. And once more facts are brought to the court and brought to us in an application, and we're putting that finer lens to it, we may then see that we need to be doing something different than the past administration showed.
Okay. We may have time for just one more question while we're all in the room. Is there another question? Yes, Randy?
What if I don't disclose expert product or expert drafts or notes or any of that? Do I have to disclose that I'm not disclosing it as in the form of a privilege list?
The federal rules and state rules may be a little different in this regard. There is, I think also in the work product rule, some designation of which of that material may be classified as work product, and under court rules of when you need to disclose what's withheld on the basis of privilege through a privilege log that may include the work product rule. So I'd say if you're in federal court, which you may well be, or in state court, the rules may differ and look closely at the federal or state rules.
It's not exempted, it's not relevant, it's just not disclosable, so we would have to assert privilege?
I think some of the thinking is that it is not relevant and outside the scope of, certainly of disclosure requirements. And I think the answer may differ if you get a disclosure, if you get a discovery request that targets that, you can object and say withholding on these grounds. And if you need to give a privilege log in connection with that objection, then explain it as you would in a privilege log. Any other questions? All right, thank you for your patience today.
And on behalf of the Water Law Review, I wanted to thank each and every one of our speakers and thank you all for being here. I know it's a long day. Please join us in the forum for a reception. We have more food and drinks for you all. Thanks.